obligations relating to the enjoyment of a safe, clean, healthy, and sustainable environment. In that role, he submitted a series of reports to the UN Human Rights Council on the application of human rights law to environmental issues, including climate change and the conservation of biological diversity. And when he concluded his mandate in 2018, he concluded the mandate by presenting framework principles on human rights and the environment to the United Nations, and by calling open the UN General Assembly to recognize the human rights to a healthy and sustainable environment. During his career, he has held several positions related to the environment and human rights. For example, from 2008 to 2012, he was Alt Counsel to the Center of International Environmental Law. He is currently on the board of the Universal Rights Group, Human Rights Institution in Geneva, and of Wake Forest University's Center for Energy, Environment, and Sustainability. Actually, John Knox is Henry C. Lowerman Professor of International Law at the University of Wake Forest Law, and he has several publications: Human Rights to a Healthy Environment, published in 2018, Reclaiming Global Environment Leadership, Why the United States Should Ratify 10 Pending and Environmental Treaties, published in 2012. And I think that now Professor John Knox is writing another book. I don't know if it was published, I don't know. The Evolution of Environmental Rights, Applying Human Rights to Environmental Protection. Professor John Knox today will present a subject which is really so interesting and in addition with the theme of the seminar, Human Rights in the Climate Crisis. Professor Knox, the floor is yours, please.
All right, thank you very much, Rama, and thank you, Mar, and to everyone here. I wish we were all together in Barcelona, truly one of the most beautiful cities in the world, but this does make it easier for us to meet this way. So, as Rama just said, I'm going to speak to you today about human rights and climate change. I'm going to share with you a PowerPoint presentation, if I can. Can everyone see this?
Yes.
Okay, thank you, perfect. All right, so I'm going to focus on three aspects of how human rights apply to climate change. First, climate change undermines the enjoyment of a vast range of human rights. Second, and as a result of the first point, states have obligations under human rights law to protect against the effects of climate change on human rights. And third, human rights institutions, courts, regional tribunals, and international human rights bodies are offering forums through which climate claims can be brought. And these are new forums that allow claims to be brought that otherwise would not be possible. So let me say a few words about each of these points. First, as Mary Robinson, the former High Commissioner for Human Rights and President of Ireland, has said, climate change poses the greatest threat to human rights in the 21st century. This is, I think, well known now, but I think it's still worth reviewing some of the reasons why. There's a lot of information on this chart, but I think the main point that needs to get across is that we are now leaving a zone of a safe climate that human civilization, for want of a better word, has been in for roughly the last 10,000 years. That is, since the end of the last ice age, we've been in a relatively safe zone in which temperatures, global average temperatures, have only moved about 1 degree. We are now leaving that safe climate zone. We have really already left it. And as a result of that, we're already experiencing the effects of climate change. But even more than that, as the science fiction author William Gibson has said, the future is already here. It's just unevenly distributed. That is, some places in the world are already experiencing the effects of climate change quite dramatically, while others are not experiencing the full effects that they will in the future. This map from Maplecroft assesses the risk of different countries to climate change, the vulnerability of different countries to climate change. They come up with a new map every year. This one's a little bit old, but sadly the basics don't change from year to year. And I like this one because it includes the names of some of the most vulnerable countries. But as you see, the most vulnerable countries are vulnerable for multiple reasons. First, they have greater vulnerability because they are, for example, in the Sahel region of Africa, or they have low-lying regions such as Bangladesh, or they're island states such as Philippines or Haiti. But they also are vulnerable because they often lack the capacity to really adapt, to help their people adapt to climate change. Other places in the world that are particularly vulnerable include the Arctic, where global warming, regional warming in the Arctic is happening nearly twice as fast as the planet as a whole. Villages, for example, in Alaska, in my own country, have already had to evacuate because of melting permafrost. Other consequences of climate change, again, are quite well understood. The increasing severity of typhoons like Typhoon Haiyan, which killed 6,000 people in the Philippines, increased flooding, such as the floods in Chennai that killed 500 people roughly in December of 2015 and displaced hundreds of thousands, probably up to 2 million more people. Hurricane Harvey, which hit Texas 3.5 years ago, destroyed 200,000 homes, caused over $100 billion in damage. And increasingly, scientists are able to identify the contribution that climate change makes, for example, to these storms or other events. So, for example, Harvey was not the first hurricane ever to hit Houston, but it did more damage than any hurricane had ever done before. And scientists think that that's because the warmer waters off the Gulf contributed to the intensity, the severity of the storm. Other problems include wildfires. California is experiencing the worst wildfires in its history. Every year they seem to get worse. The so-called Paradise Fire of 2 years ago killed 80 people and destroyed hundreds of thousands of acres of land. Last year, however, I think it got less attention because of the pandemic, but last year was actually by far the worst year in Californian wildfire history. Of the largest fires in California history, 5 of them occurred in 2020. And again, this is directly related to climate change. California has been in a drought for many years. It has experienced almost no rainfall in much of the state, and so as a result, it's a tinderbox waiting to explode when lightning strikes or anything else starts a fire. Australia, of course, had the worst fire season in its history last year. Again, I think that this has been somewhat overshadowed by the pandemic, but Australia's wildfires were truly massive, destroying millions of acres of forest and wiping out many animals and homes of people. And again, this is directly related to the drought conditions that Australia had been in. This map shows how much precipitation parts of Australia had received in the preceding year, or the preceding 6 months from July to December of 2019. And you can see that much of Australia received no precipitation over that period. And again, this is the percent of the average. So almost nowhere in Australia was it even at average levels, and much of it was at extremely low percentages. I could go on indefinitely. Let me just mention one other huge problem, and that is rising sea levels. Bangladesh, for example, is essentially at the confluence of some of the greatest rivers in the world, and so much of it is effectively a river delta. Because sea levels are going to inexorably rise as a result of climate change, much of Bangladesh that is under a meter above sea level is going to be inundated, and as a result, millions of people are going to be displaced. For small island states like Kiribati and other states such as the Maldives that are essentially coral atolls, a rise of a meter will make those states virtually uninhabitable. This is the highest point in South Tarawa, the main island of Kiribati, and as you can see, it's only 3 meters above sea level. So for small island states, the climate crisis is truly an existential crisis. So what does human rights law have to say about this? Well, starting really 15 years ago, when the Inuit people of the Arctic brought a petition to the Inter-American Commission on Human Rights, increasingly it's become clear that these kinds of effects interfere with a vast range of human rights. The Inuit petition to the Inter-American Commission described how climate change was already interfering with their rights to life, to culture, to food, to housing. Small island states, 2 years later in the Male Declaration, similarly tried to bring human rights to bear on climate change. I had the honor of working on a pro bono basis for the Maldives for a few years in those days. And the goal of the Maldives was to try to use human rights to put a human face on the threats that they were facing. Part of their strategy to do that was to bring climate change to United Nations human rights bodies, which they did successfully. Together with allied states, they convinced the Human Rights Council to start addressing climate change on a regular basis. And in one of its first resolutions in March 2008, the Human Rights Council asked the Office of the High Commissioner for Human Rights to prepare a report on human rights and climate change, which it did in January of 2009. I go back this far, I think, because it's important to realize the roots of this issue now are actually pretty deep. That is, we've been looking at the effects of climate change on human rights now for over a decade, and there's almost no argument left that climate change does in fact interfere with human rights. In the OHCHR report, again, they were already describing the way that climate change through fires, through droughts, through flooding, through hurricanes was interfering with people's ability to enjoy their rights to life and health, as well as many other human rights. By the time of 2014, all of the then about 80 special mandate holders, the special rapporteurs and members of working groups for the United Nations Human Rights Council, joined together to issue a joint statement on the occasion of Human Rights Day, in December of 2014, which happened to coincide with the meeting of the parties to the UN Framework Convention on Climate Change, which was negotiating the what would then become the Paris Agreement the following year. This is significant because it was the first time that all of the special mandate holders came together to say that climate change is an enormous risk and threat to not only to the environment, human health, water, food, and that all of these impacts interfere with the effective enjoyment of human rights. And in keeping with the theme of the conference today, I wanted to emphasize that the mandate holders emphasized then that climate change has a disproportionate effect on many disadvantaged, marginalized, excluded, and vulnerable individuals and groups. At the same time, the special rapporteurs always try to emphasize that people need to be understood as not just victims, but also as agents. So all individuals, regardless of, without any discrimination, should be considered as a resource for resilience, and they should be allowed and recognized to be able to participate in resilience building activities. More recently, the treaty bodies, I went a little too far past that one. More recently, just 2 years ago, the 5 treaty bodies for CEDAW, the ICESCR, the Covenant on Economic, Social, and Cultural Rights, the Convention on the Rights of the Child, the Convention on Migrant Workers, and the Convention on the Rights of People with Disabilities joined together to, again, say that the adverse impacts of climate change, in that case, and they were most recently referring to the IPCC's report on the effects of even a 1.5 degree increase in global average temperature, they came together to say that these impacts threaten, again, the right to life, the right to food, the right to housing, and so forth. And again, they emphasize the importance of recognizing that the risk is particularly high for segments of the population already marginalized or in vulnerable situations, and that can include women, children, persons with disabilities, indigenous persons, and so forth. So there's really, I think, as much as you can say anything is free of doubt in international human rights law or in environmental protection, I think it's free from doubt that climate change does, in fact, interfere with a vast range of human rights. So the second point, states therefore have duties to protect human rights from climate change. And that's part of and encompassed by, excuse me, states' more general positive duty to protect all human rights from all types of environmental harm. And I, in my capacity as first the independent expert and then the special rapporteur, spent a great deal of time describing the ways that over the past 25 years and longer now, human rights bodies have greened human rights. What do I mean by that? As we all know, there is no globally recognized human right to a healthy environment, although many states, in fact, most states in the world, have recognized it at the national level or through regional treaties. But in the absence even of a global overarching right to a healthy environment, human rights bodies at the international level have taken existing human rights, like rights to life and health, and greened them. That is, they have applied them to environmental issues. And there are many, many examples of this. The European Court of Human Rights has focused on the rights to life and to private and family life, protected by Articles 2 and 8 of the European Convention. The African Commission on Human and People's Rights has issued cases talking about the right to health and the right to a healthy environment, which does exist in the African Charter. The Inter-American Commission has issued decisions on non-discrimination and indigenous peoples and so forth. But the point is that putting these cases together, this jurisprudence forms a coherent whole. In my last report to the Human Rights Council in 2018, as Rama mentioned, I called on the Council to finally recognize, well, the UN generally, to finally recognize the human right to a healthy environment. But I also gave the Council what I called framework principles on human rights and the environment, which summarize how the existing human rights obligations have already been applied to environmental issues. So I described ways that states have to protect, oh, sorry, I didn't want to go to that slide yet, have to protect against the effects of climate change, against the effects of environmental degradation generally, I mean to say, on human rights. And these obligations include duties of procedure, that is, they have to make sure that people have the right of information, that they are able to participate in environmental governance, that they have access to remedies, that their freedom of expression and association apply in the environmental context. They also have obligations of substance, that is, they have to actually set environmental standards at levels that protect human rights, and they have to make sure that those standards are enforced. And finally, I described obligations relating to those who are most vulnerable or at risk from environmental harm. And I set out, obviously, application of non-discrimination principles to environmental protection. But also, I emphasized the importance of taking into account vulnerable situations and states having to take additional steps to ensure protection of human rights from environmental harm to those who are most vulnerable. Again, all of these obligations apply in the context of climate change. The treaty bodies, the 5 treaty bodies joint statement just 2 years ago said state parties have obligations, including extraterritorial obligations, to respect, protect, and fulfill all human rights, and failure to take measures to prevent foreseeable human rights harm caused by climate change could constitute a violation of states' human rights obligations. So let's break down a little bit more clearly what those duties require in the context of climate change, because I think their obligations are different in relation to 3 different areas. First, adaptation, second, mitigation, and finally, in the connection with the response actions they take. First, adaptation. I think adaptation in many ways is the simplest and maybe most obvious way in which states have obligations in relation to climate change. Every state has a duty to help its citizens adjust to, respond to, and try and protect them from the effects of all kinds of environmental harm, and certainly that includes climate change. And the important thing is here that duty applies whether or not the state is individually responsible. For example, the European Court of Human Rights held in a case involving a mudslide in Russia that Russia had failed to comply with its duties under the Article 2 of the European Convention with respect to protection of the right to life by not notifying and taking steps to try and protect villagers in the path of a foreseeable mudslide. No one thought that Russia in any way was responsible for the mudslide. The mudslide itself didn't violate human rights, but because Russia had not done the kind of obvious things they could have done to warn the town in the path of the mudslide and to try and take measures to protect them from it, then they had violated their duties under the European Convention. And so with climate change. So even, for example, a state like the Maldives, and this is a picture of Malé, the capital island of the Maldives, an island nation in the Indian Ocean. Even a state like the Maldives, while certainly they don't really contribute in any significant way to climate change, there's only 300,000 people on the entire country, they still have an obligation to try and help their citizens, those within their jurisdiction, adapt. And so the Maldives has in fact taken steps like building seawalls. I don't know how clearly you can see it here, but building seawalls around Malé and trying to do other things to help their citizens adjust to the harms of climate change. Again, I think that is fairly straightforward under international human rights law. Mitigation is harder because many states do not contribute in any significant way to climate change. Nevertheless, I think it's fair to say that collectively, states must adopt mitigation measures necessary to reduce global emissions at levels to keep overall temperature rise below 2 degrees Celsius. But collective and individual obligations are a different thing, right? And so when we look at the effects of climate change, it's important to bear in mind that a relatively small group of states emit the vast majority of greenhouse gas emissions. So China, the United States, the European Union together emit about 1/2 of all greenhouse gas emissions. And then if you put in India, Russia, Japan, and the other top emitters, pretty quickly you get to another quarter. So about 10 states emit roughly 3/4 of all greenhouse gas emissions. This raises the question of whether these states have extraterritorial obligations under human rights law. And this is, of course, an old debate in human rights law. How far do states' obligations under human rights law extend? Do they extend to people in other countries? The International Covenant on Civil and Political Rights seems to suggest that the answer is no. It has a specific jurisdictional clause that limits, apparently, its obligations on each state party to those within its territory and subject to its jurisdiction. But the Covenant on Economic, Social, and Cultural Rights not only does not have that restrictive clause, but actually refers to international assistance and cooperation. And again, the treaty bodies that interpret the International Covenant on Economic, Social, and Cultural Rights, the CRC on children's rights, and CEDAW, for example, on the rights of women, have all emphasized that states do have extraterritorial obligations and that they must work together. Sorry, that flipped forward a little too fast there. That they must work together to support adaptation and mitigation efforts in developing countries, including by financing climate mitigation and adaptation. In my own reports to the United Nations Human Rights Council, I emphasize the duty of cooperation, which exists not only in the Covenant, but also in the Charter of the United Nations itself, and is recognized in the UN Framework Convention on Climate Change. That is, that states have a duty to cooperate together, to work together, to deal with problems that have a global scope, such as climate change. And of course, states have in many ways worked together, most recently in the Paris Agreement adopted in 2015. In the Paris Agreement, As we know, the Paris Agreement includes this goal of limiting the increase in global average temperature to well below 2 degrees and to try and keep it to 1.5 degrees. And it provides for measures to do this through adaptation, through assistance from poorer countries, and through nationally determined contributions by which each country determines for itself its own contribution to mitigation. The problem with all of this, of course, is that, as UNEP said the year following the Paris Agreement, even if fully implemented, the nationally determined contributions are only going to keep the increase to about 3 degrees Celsius. And that's very far from what was promised. I'm sure you've all seen charts like this that show that if nothing was done, then warming would be, in the range of 4 to 5 or even 6 degrees Celsius. Current policies are aiming maybe at 3.5 or 4 degrees. But the problem is that the nationally determined contributions, even if you adjust for them, at best they will get you below 3 degrees, but nowhere near 2 or 1.5 degrees. So there's a huge gap between what states have said is necessary and what's actually promised. And so in my report to the Human Rights Council on this, I said it's clear that even if they meet their current commitments, states won't satisfy their human rights obligations. And therefore, it's necessary not only to implement what they've already said they're going to do, but also strengthen those contributions. So I've talked about adaptation and mitigation. Just very briefly, I want to point out that in responding to climate change, for example, in adopting new renewable energy projects, it's still important to comply with human rights obligations, and some states have not always done so. There have been allegations, credible, supported allegations of huge human rights violations in relation to some renewable energy projects, especially big hydroelectric dam projects, which often are built by displacing indigenous peoples without their consent or even consultation. The Paris Agreement in its preamble emphasizes that parties should remember their obligations on human rights when taking action to address climate change, but safeguards to do so in climate finance mechanisms vary quite a lot. The Adaptation Fund is pretty good on this. The Clean Development Mechanism historically was quite bad. The Green Climate Fund, it's still to be determined. So there's still some work to be done to make sure that as states do spend money on new measures, they don't actually make things worse from a human rights perspective. Obviously, a lot more could be said about how human rights law applies to climate change in these respects, and maybe we can get more into that discussion after these slides. But now I just want to briefly describe the third point, that is that a human rights framework opens new forums for claims, and that's true at the national level, at the regional level, and at the international treaty body level. Not all claims are successful. The Inuit petition, for example, that I referred to earlier, that was filed in 2005, did not result in a decision from the Inter-American Commission. It didn't even result in a decision denying it. The Inter-American Commission at the time, it was truly a case before its time. The Inter-American Commission didn't know what to do with it and ended up just saying, let's have a hearing and we can talk about these issues, but we're not going to issue a decision. But things have changed since then. In the last 5 years, we've seen a true outpouring of judicial decision-making on this. One of the early cases was the Asghar Laghari case. This was brought by a farmer against the government of Pakistan. And in 2015, a Pakistan court said that the Pakistan government's failure to actually take steps to implement its climate action plan violated the right to life protected in the Pakistani constitution of the Pakistani people. And so it ordered the government, the court actually appointed a commission chaired by Parvez Hassan, a leading Pakistan environmental attorney, to essentially do what the government had failed to do, which is come up with an action plan to implement its obligations with respect to climate change. In the United States, a well-known case here has been Juliana versus United States, which was a case brought by a number of children and youth which again resulted in a favorable decision in 2016. But then the government appealed and won on appeal on the basis that the court decided that it did not have standing. But the interesting thing about this case, again, is that it was brought on the idea that children and youth have a right to a stable climate that's protected by the U.S. Constitution. At the regional level, the Inter-American Court of Human Rights issued a really wide-ranging advisory opinion on human rights and the environment in 2017, which, among other things, said that states do have obligations, at least under inter-American jurisprudence, under the American Convention. They do have obligations to protect against transboundary harm. In Colombia, the following year, another case brought by children and youth was upheld by the Supreme Court. Another case complaining that, in this case, Colombia's failure to take steps to protect the Amazon violated these children's right to a healthy environment under Colombian law. The Supreme Court agreed and ordered the government to take more concrete steps. Probably the most famous decision is the Urgenda case, which I'm sure all of you know about. But just to reiterate, the Urgenda case was the first time that a national Supreme Court, in this case the Dutch Supreme Court, had held that a state had failed to comply with human rights, and especially the rights to life and to private and family life under the European Convention, and therefore had to reduce its greenhouse gas emissions more rapidly than it otherwise would. I know you're going to hear a presentation that goes into climate change litigation later this afternoon, so I'll be brief with the remaining ones. Cases, successful cases were decided in Ireland, in France, and not all cases have won. Obviously, Norway recently rejected a similar constitutional-based claim, but nevertheless, there's again a trend toward more decisions. Two to keep this is also one that was decided last year by the Human Rights Committee, the oversight body for the International Covenant on Civil and Political Rights. In this case, the committee suggested, really again for the first time, that if a country sent someone back to a small island state, that could give rise to a claim for violation of their human rights if the small island state had become uninhabitable or was in imminent danger of becoming uninhabitable as a result of climate change. In that particular case, they said New Zealand had not violated Mr. Te Tiota's human rights because Kiribati, the country he was a national of, had not yet become uninhabitable, but the Human Rights Committee suggested that could well change in the foreseeable future. Two pending cases to keep an eye on that might be decided as soon as the next 2 or 3 months are the Torres Strait Islanders case versus Australia. This is again before the Human Rights Committee, and in that case, the Islanders argue that Australia has violated their human rights under the covenant by not adequately mitigating and helping them adapt to climate change. And then a case brought by Greta Thunberg and a number of other children and youth to the Committee of the Convention on the Rights of the Child against 5 members of the convention who've accepted the jurisdiction of the committee. And again, they're arguing that the state's failure to take adequate steps to reduce greenhouse gas emissions violates their human rights. There are pending cases before the European Court of Human Rights brought by children and youth in Portugal and senior women from Switzerland. And there are other pending cases around the world as well. So there's just again, a huge outpouring of cases. And the lessons I would draw so far from these cases are, again, that rights-based claims are opening new forums and that courts are increasingly willing to hear such claims if they're based on human rights law. The claims often draw on states' commitments under domestic law or international environmental law, as well as they draw on scientific findings. The plaintiffs are often youth and children because that gives essentially more clout to the idea that this is having lifetime effects on them. International and domestic courts are listening to each other on this. They cite each other's decisions. But at the same time, there are downsides or limits to this approach. The most important one is that the 2 biggest emitters, China and the United States, are extremely unlikely to pay attention to decisions like this. So as a result, I think it's a crucial tool, but it definitely will not be enough by itself. And then I think we could say about the human rights approach generally. I think it's a crucial tool to addressing climate change, but we should not think that by itself it's going to solve the problem, or that we still have to use all of the tools at our disposal as well. That concludes my talk. For those of you who want to follow more issues on human rights and the environment, I'm on Twitter. I always feel a little silly saying that, but I actually find Twitter a pretty useful way to share information about these issues. So I encourage you to use it in that respect. I promise that I don't tweet very much about the Kardashians or Meghan and Harry or whatever might be going on there, just human rights and the environment. So that concludes my talk. And again, thank you very much for inviting me to be with you today. And I'm happy to take questions or engage in a discussion however you like.
Thank you very much for this beautiful and very interesting presentation, which has traced with great accuracy the extremely close relationship between human rights, vulnerability, and climate change. And I must admit that I realized from the presentation of Professor John Knox that vulnerability is a vulnerability of the planetary system. It is no longer enough today, I think, to talk about a notion of vulnerability or a concept or a principle. I think we are faced with a planetary vulnerability that goes beyond the environment, that goes beyond the climate change. And at the heart of this global sensitivity, there are obviously human rights that are at the heart. Some authors are talking to us today about rights to a healthy planet, or the rights to biodiversity, or rights to a stable climate, which responds to this logic presented by Professor John Knox. And what we can underline above all is the existence of a very complicated, but I think complementary synergy between the legal arsenal and the activism of the courts concerning human rights, climate crisis. As you mentioned, there is a kind of globalization, even if differentiated, of human rights to the environment, which is recognized by different courts, African, Latin American, and European courts. So thank you, really thank you so much for this interesting presentation, and the debate is open and welcome to all questions. Yes, so I see here in the chat that we have a first question from Professor Alex Peñalver, professor at the University of Barcelona. Is the greening of individual civil human rights on climate change a sign of weak protection of the human right to environment?
So yes, that's a really interesting and valuable question. I think if it's possible, I think I would say yes and no. So I think, yes, it is a sign of the weakness of the protection of human right to a healthy environment, in the sense that if there was a globally recognized human right to a healthy environment, I think many of these claims would be brought using that as their foundation. And since there is no such right, then these claimants turn to other rights and make the argument there. But at the same time, I think it also indicates that environmental protection really does interact with and implicate a very wide range of human rights. So it's not a stretch by any means to say that environmental harm interferes with the right to life or the right to health. It's fitting, it's appropriate to make those claims. What I tried to do as this special rapporteur was to explain how the body of law that was being created, the body of norms that can be called environmental human rights law, not only showed a kind of consistency from right to right, but also built together the content of what could be the human right to a healthy environment. In other words, what I was trying to say is, unlike the usual situation where you identify the right and then over time the content gets elaborated, in this case, the international community has really done it in the reverse order. They have identified much of the content of the right through this case law, and now they need to actually put the capstone on. They need to declare that there is a human right to a healthy environment.
Thank you. We have a question from Gonzalo Larrea. Gonzalo, yes?
Hi, can you hear me?
Yes.
Okay. Professor John Knox, thank you so much for your presentation. It was really interesting. I am a PhD researcher and I am working on climate change law. And I have a question on accountability, on how a human rights regime can contribute to accountability. If we consider accountability as a right of an account holder to set an account giver to certain standards so that the account holder can call on the account giver to justify a conduct and provide some remedy. And so, so you mentioned the several cases, including the Urgenda case, but these were basically, or at least Urgenda was basically a tort law case in a jurisdiction of a country, of the Netherlands, which was making use of the public power as a leviathan, as a state. So there is not so much, there are not so many problems or issues in terms of raising accountability. But when we get out of the traditional understandings of public power and enforceability and so on and so forth, and we start talking about human rights, well, they definitely contribute to setting these standards, right? Human rights is a sort of language through which we can talk about standards and minimum care and duty of care and so on and so forth. But how about enforceability? How can these forums contribute to enforcing these standards, these principles, these rules? Will they ever become a sort of tool as we traditionally understand the judicial tool from a national jurisdiction such as the Netherlands, and as it happened with the Urgenda case? Or we will just have to be okay about the fact that they are a complementary tool on the fight against climate change? They are a complementary tool on the setting these sort of standards and creating this language, but it will only be that. Thank you very much.
Well, I think in a sense, all courts are always a complementary tool to environmental regulation. I mean, you can't expect courts to actually do the regulatory work that you have to have the government doing. Courts can't substitute themselves for the government's actions. But I do think what claims like this have shown is that a rights-based approach can have at least 2 or 3 different kinds of effects that make governments and other actors more accountable. So one is it can simply check to see whether the governments or the other actors are living up to their obligations. Now, you're certainly right that human rights law is primarily directed against governments. It's states that have the obligation under human rights law. But while that's certainly a limitation, I don't regard it as much of a weakness in this situation as it might otherwise be, because it's states that are primarily failing to live up to what they need to do. In other words, if courts can be ordering states to do more, then through state government regulation, the governments can then require the private actors to do more. So I think actually that's a strength of human rights law, that it goes after states. Now, in terms of true accountability, as you suggest, not all courts are going to be able to or have proved willing to issue these kinds of decisions, and not all governments will comply with them. And that's certainly a weakness. But I don't think it's more of a weakness in this situation than it is in every other situation. That is, state, a government that's simply refusing to do anything on climate change, the difficulty of forcing it to do that is a difficulty that there is no magic wand that can solve. So I think in that respect, again, the advantage of courts may be not just that they clarify what the standards are, but that they also make clear that individuals and communities have rights to participate in the decision-making process. That is, that they can help bring public pressure. They can clear the obstacles to public pressure being brought on states, which I think is ultimately maybe the best way, that the best kind of pressure to produce the outcomes we need. Again, is that always going to work? No, not all states will respond to that pressure. I mean, there are many places in the world where environmental defenders are enormously at risk. That's not going to change magically. But I do think courts and a rights-based approach in particular have a really important role to play in trying to protect, again, the rights of individuals to actually push for change within their own systems.
Thank you. Are there other questions? Yes, Mar.
Yes, thank you very much, Professor Knox, for such an interesting talk. I'm not an expert on human rights. I just have a question that's probably very, maybe a silly question too, but actually, when you mentioned the different cases on the climate litigation, you didn't mention the Carvalho case, if I'm not wrong. And I think that it's quite, representative of what's happening at European Union level and what are consequences of the strict conditions on the standing for individuals. So what's your position on that? I mean, on the situation of the European Union concerning the Aarhus Convention for the access to justice and etc. Thank you.
Yeah, no, I did have a slide. I don't think I showed it, but I did have a slide on the losing cases. And Carvalho, as you just said, they lost their appeal at the European Union level, the ECJ level. Certainly a lot of cases have lost on standing grounds. That is, the court has essentially said, we don't have jurisdiction to hear your case because, in the United States, for example, the idea is that in the Juliana case, they dismissed it because the court said, we don't have the power to issue the relief you're requesting. This is really a matter for the legislature and the politicians. You should take your cause up with them. In the Dutch case, under Agenda, the court rejected that argument, saying basically, we're a court, we can say what the law is. But I think it remains to be seen how many courts will follow the Agenda approach and how many of them will follow the Carvalho or the Juliana approach. I think a significant percentage of courts are still reluctant to take on the issue in the way that the Agenda court did. Having said that, I think there's still a lot of benefit to courts doing what the Asghar-Laghari court did, which is say, not we're telling you what your answers should be, but we are telling you you have to do more to try and arrive at an answer. You have to actually come up with a commission. You have to have procedures. You have to make decisions. Even in the United States, going back now over a decade, the Massachusetts case against EPA that forced EPA to actually decide whether carbon dioxide would be treated as a pollutant under existing Clean Air Act, under existing air pollution law. That was not a rights-based case in the sense I'm talking about, but it illustrates, I think, a way that courts can be useful, even again, if they're not willing to tell governments exactly what they have to do. So I guess that, I don't know if that totally answers your question, but that's, I think it's the benefit, what courts are going to be able to do is going to vary enormously from country to country. But I think even in countries where they can't do as much as the Dutch Supreme Court did, I think there's still quite a bit of benefit that can be achieved.
Thank you. We have another question from Professor Mar Aguilera Vaquez.
Hi, thanks a lot for your, can you hear me?
Yes,
Yes.
very well.
Thanks a lot for your presentation. It was really interesting. And it's more like a comment what I wanted to say. It's that, or maybe a question, what you all think about this, especially you, Professor Knox, which is, after seeing all these cases and after all these discussions we had here, I was wondering if it might end up like what happened with the due process of law, or what happened with the rights of the foreigners. Like case by case, maybe we will end up having a kind of due process of environmental protection. Like case by case, layer by layer, maybe courts will end up saying, in these human rights courts, may end up saying, okay, we are not going to define what is the right to this environment or to this climate change protection right, but we are going to say that at least we need this, and maybe this can end up being effective and grant some implementation, because if not, all these singular cases, maybe this might be the last aim of all these cases, that layer by layer we will end up doing a kind of due process of environmental right.
I think that's very well put. I agree with that. I think much of the attention in this area goes to the highest profile cases like Urgenda, but there are a very large number of cases that are seeking less sweeping remedies, but that little by little do build up into, again, what I think of as a very coherent set of norms. There was an interesting article, I guess a little bit over a year ago now, published in the American Journal of International Law by Jacqueline Peel and Jolene Lin that I encourage you to look at if this is of interest, focusing on climate litigation in the global south. Again, saying that the global north cases like, Urgenda and even the unsuccessful ones like Juliana get a lot of attention. But they went and looked at cases in the global south and found a very wide variety of cases. And as you're suggesting, many of those cases do not try to take on all emissions in the entire country. They're focused on particular projects, but they are contributing to this growing jurisprudence that is limiting or bringing often constitutional rights or international human rights to bear on climate change. And little by little, that does create a kind of a legal framework that other cases can then build on.
Thanks a lot. Thank you.
Thank you. Are there other questions? No. I have two questions, if I permit, to Professor John Knox. My first question, I don't know, according to your experience in practice as a former UN rapporteur, is there really a state political will to respect these obligations by states? I mean, as an academic, but outside of the system of UN, I would be interested to know if, for example, there have been cases where some states have refused or for certain political or conflict reasons to partially implement these obligations that you mentioned concerning the adaptation and mitigation. And my second question concerns the institutional will to recognize the human rights to a healthy environment. Do you think that there will always be resistance to recognize this right from the outside, mainly for, I don't know, financial reason or for fear or compensation for victims? I'm asking the question because I know that within the Council of Europe, there is resistance to express recognition in a convention or a protocol for this right to environment, a healthy environment. And I confess to you that while finishing the drafting of my book on human rights to a healthy environment in European law, I was quite a lot of times disappointed by some decisions of the organs of the Council of Europe.
So those are both very good questions. So on the first one, no, again, no one should think that human rights law is is certain to result in changes. I mean, when I very first began on this now, maybe a decade ago, when I guess my appointment started in 2012, but even before that, I would spend a lot of time talking to environmental groups and explaining human rights law to them, and talking to human rights groups and explaining environmental issues to them. And that has really developed. I mean, I think human rights and environmental, let's say, fields are much more aware of each other now. But I think in the early days, environmentalists may have thought that if we could only get these issues framed in human rights terms, that would solve so many problems for us. But of course, human rights scholars and advocates could tell them, and did tell them, that's only the beginning of the fight, right? I mean, governments don't comply with human rights in all kinds of ways. So of course, they're not going to automatically comply with them in the environmental context. But at the same time, it does give you advantages. We've talked about some of the advantages today. It gives you a clear normative framework that's extremely widely accepted. It provides rhetorical power in that sense. It also gives you access to an existing international, but also domestic and regional legal framework. And finally, it gives you access to forums that don't otherwise exist. Many of these rights-based climate cases, for example, simply could not be brought if they weren't being framed in human rights terms. So while they certainly, again, leave a lot to be desired in terms of their ability to convince all governments, I tend to look at it, I guess, as a glass half full. At least they convince some governments and they push for some change. And by doing that, they make it clearer that this change is possible, which may, again, make it easier to convince other governments to go along. In terms of, and that kind of takes me to your second question, when I first started on this, many governments resisted the whole idea of a connection between human rights and the environment. And that has really changed quite dramatically. And so, over time, the resolutions at the Human Rights Council on my mandate, every year it would have to be, there would be a resolution on my reports and what was going on. They were all adopted by consensus, even though the resolutions got stronger and stronger and were calling on states to do more and more. There was never a negative vote. Most recently, I and my successor as the rapporteur, David Boyd, have continued to push for recognition of the global human right. At the most recent Human Rights Council session, just in March, that became closer to reality than it ever had before. The High Commissioner for Human Rights, the Executive Director of the UN Environment Program, the Executive Director of the UN Development Program, UNICEF, and I think a total of 16 UN agencies issued a joint statement in favor of it. 69 states issued a joint statement saying that they were pursuing discussions towards it. And I think there's growing momentum for at least introducing a resolution on it in the fall at the General Assembly. Now, some states, including my own country of the United States and countries like the United Kingdom, are still quite skeptical about this right. But I think it's increasingly likely that there may be recognition of it. And if so, it would follow the path taken by the right to water and sanitation in 2010. That right, like the right to environment, had a lot of support, but was never formally included in a global human rights treaty. And the General Assembly in 2010 finally said, we accept that it's part of human rights law. It's necessary to health, to an adequate standard of living, and many other rights. And that's what I'm hopeful will eventually happen for the right to a healthy environment.
That's perfect. Thank you. Thank you so much for all this clarification, for all this interesting information. It was really a pleasure for us to meet you in this seminar, and I hope that we will have other opportunities to meet each other in other academic seminars, perhaps next time in Barcelona and without yeah, thank you.
That would be lovely. Thank you again, Rama, so much for inviting me, and to all of you. I would love to be present for the rest of the sessions. I have to teach class in an hour, though, so I may have to drop off for that. But thank you again very much.
Thank you.
Thank you so much. Yeah. So, Mar, I think for the moment we will take 3-4 minutes, really small break, and we move directly to the other session.
Yeah, we can take 4 minutes, and then we'll just come back and resume our session. So please don't leave.
Yeah.
just use these 4 minutes to have a break, and we will resume immediately. Okay.
Okay, that's perfect. See you. Thank you. Good.
Bye.
Hello, Mark. I'm not listening to you. Je t'écoute pas.
Yes, sorry. I have.
Yeah, that's perfect. Listen, I don't find the email, the complete program to introduce the subject of Delphine Ducasse, the title of her presentation.
Yeah, it's the one which is okay. So you have it. Yeah. Let me see. I'm sending it to you.
Yeah.
Okay, that's okay. You don't have it. Okay. Okay, I have already sent it to you,
Okay.
and maybe you can just we can just start. What do you think? Have everybody here? Yeah. You actually you have it into into the folder.
It's into the folder. Yeah, I will just.
I just sent it to you.
Yeah, it is here. Find it.
I think we can resume. What do you think?
Yeah, it's here.
Yeah, Rama?
Yes, we can start.
Yes, of course.
Yeah, thank you. So, welcome to this fourth and final session of the day, and I will start by introducing briefly our panelists. You will see that here we subscribe this session to continue the talk and debates concerning relationship between human rights and climate changes. We have with us today Professor Nathalie Hervé-Fournereau, who is co-director of the RTP BO10 at CNRS, the vice-president of the French Society of International Law and co-chair Research Committee, Academy Environmental Law. Nathalie will deal with taking seriously the vulnerabilities of indigenous people to climate change, the ambivalent legal responses of the European Union. Professora Susana Borràs Pentinat, professor on international environmental law at the University of Riviera e Virgili, will talk about gender climate justice. It is another approach of human rights, climate human rights. Gender climate justice is in a context of intersectional vulnerabilities. Doctora Rosa Fernández Egea, who is lecturer in public international law, and she has carried out research at various foreign centers and participated in several editorial projects as a member of the editorial board of the Revista Electrónica de Estudios Internacionales and Revista Jurídica de la UAM. Professor Rosa Fernández will talk about climate change litigation and human rights, addressing the rights of future generations. And finally, Mrs. Delphine Ducasse, who is PhD candidate at the University of Sherbrooke. She is working on the systemic legal impact of the inclusion of environmental and labor standards in free trade agreements, and her presentation today is linked to her PhD subject. So, Nathalie, floor is yours. You can begin. Yes.
Yes, thank you. Thank you very much. Good afternoon, everybody. Is it possible just to put my presentation on the screen?
Oh, yes. Do you want me to?
Yeah, thanks.
You are a presenter, so you can manage yourself, but I'm just sharing.
Yeah.
I'm sharing now the presentation. You only need to move the presentation on the bottom. You see that you have the, okay, you can move that.
Okay, so thank you. Thank you very much, Maren Rama, for the invitation. It's always a great pleasure to share my reflection with colleagues, even if I'm little or too sad not to be together in person and not share a moment of conviviality too. In the time I am allowed, I had preferred to write a detailed presentation with my PowerPoint to facilitate the following of the pathway of my reasoning. The topic of vulnerabilities of indigenous people in the context of climate change is dramatically important and complex. So, taking seriously this issue constitutes an existential imperative for humankind. For this presentation today, I decided not to focus on the legal characterization or qualification of the multi-spatio-temporal or institutional vulnerabilities of indigenous people. I prefer this afternoon to focus my presentation on the ambivalent legal response of the EU to take into account these vulnerabilities, to respect their right, and to not affect more the capacity of indigenous people, even enhance the capacity to adapt to this dramatic socio-ecological crisis and injustice amplified by the climate change. I will give you 3 introductory remarks before propose 3 major recommendations to go beyond the ambivalent legal response of the EU. As I said just before, taking seriously the vulnerabilities of indigenous people to climate change need to take seriously the incontestable fact, the imperative respect of human rights and indigenous rights, and to keep in mind the multidimensional responsibility of the EU. In brief, the incontestable facts are really well known. 2 aspects. The first is that the climate change exacerbates and amplifies the multi-vulnerabilities of indigenous people with dramatic impact. But the fact that we can see again and now emergence of economic activities with high greenhouse gas emission potential with impact of indigenous territories and the dramatic socio-ecological injustice. So it's very time now to go beyond speech of empathy of decision maker responsible of climate change. But we have also to keep in mind that the climate change solution may increase vulnerabilities of indigenous people. Everybody have in mind the question and the controversial question of geoengineering or the ambivalent use of nature-based solution. And of course, the risk of ignoring the knowledge, the value, and the need of indigenous people. My second introductory remark concerns the respect of human and indigenous rights. Just you have seen before, thanks Professor Knox, that we can find many interactions between climate change and human rights. Of course, negative impact of climate change of the exercise of rights, and the necessity to take into account the impact of solution, of mitigation, of adaptation to climate change on human rights. We also need to take into account the singularity of indigenous people rights, collective dimension of indigenous people rights, of course, but the existence of very variable legal recognition among states of international organization, even regional integration of organizations of the EU. And I just give you a few examples of the different rights for indigenous people. My third remark concerns the multidimensional responsibility of the EU. I give you some few aspects and overview of this question. Of course, we need to take into account the various type of EU competencies related to this topic. It's very strange to observe that the EU has sort of international topics related to the question of the vulnerability of indigenous people. A clear priority as put by the EU for this question in the light of international relationship. Another thing it's very important to take into account is the diversity of the EU responsibility at different scale. Of course, related to the member state, the role of member states, but the role, of course, of a different company and all EU policy is concerned. Another thing it's need to take into account is the question of how to go beyond the discourse of the EU and to observe the reality on the ground. Related to the respect of indigenous rights and knowledge, we also observe persistence of legal inconsistency and inadequacy. The question could be if the European Green Deal be a sufficient response to ensure that no one is left behind, including the indigenous people. We can observe also many challenges, actually. For example, I give you a very few examples, but for example, the future Mercosur agreement, the future of the Arctic region, the question of the extractive industry and rare earth, imported deforestation, etc., etc. So we can see really a lot of challenge for the EU to respect the question of indigenous people to climate change. So, as I said before, I propose three recommendations to go beyond. My first recommendation to go beyond is to strengthen the integration of respect for indigenous people in the EU policy. Two remarks concerning this first recommendation. I think it's very important for the EU to build and to adopt a real integrated Europe strategy to respect rights of indigenous people, to respect their capacity and their knowledge. In this European strategy, we can imagine it's very important that all European policy concern, not only the policy which contribute to climate change, all the European authorities and also national authorities, including financial public institutions, and of course all firms with activity which may affect the right of indigenous people. So I think that's very important for the EU to adopt such strategy. And my second remark concerning this first recommendation is to try to strengthen and systematize the sustainability impact assessment of the EU related all its policy and action, and to find and to determine a robust impact assessment methodology to do this, and to ensure a real transparency and to ensure also a democratic nature of this procedure. For example, I just gave you the example of the Mercosur agreement, and I think it's very important to ensure that impact assessment procedure could be and need to be binding for trade and investment agreement before the end of negotiation, in particular in the light of the question of indigenous people rights affected by climate change. My second recommendation to go beyond the ambivalent legal response of EU is to build a more stronger binding European framework to do this. Two remarks and two components, two elements to try to build such a binding European framework. I think that the heart of this European strategy need to have and need to focus the accent of the linkage between human rights, indigenous people, and climate change. Of course, diplomatic speech, political dialogue, strategic orientation, etc., could be and need to be reinforced and are very useful, but they are not sufficient to respond to the question of the vulnerability of indigenous people. I propose a different idea to try to go beyond, for example, answering the binding nature of sustainable development, chapter on environment and the chapter of indigenous rights in the trade and investment agreement between EU and third countries. I think it's very important to be aware of this aspect. And I think that's very important to think about the inclusion of indigenous people rights in environmental impact assessment and over environmental procedure. I just put the accent also on the proposal of the Commission, European Commission, in the Green Deal. It's a proposal related a reflection concerning a regulatory to promote imported products and value chain that do not involve deforestation and forest products. It could be a good way to try to force the respect of indigenous people and to take into consideration the vulnerabilities of indigenous people. Another element of this binding European framework need to take into account the necessity to reinforce this binding framework from its development to the implementation, including the question of the sanction and the question of the judicial review. So I give you from proposal related the importance to reinforce sort of mechanism to monitoring, to assess, to control, and to receive the different complaints of the indigenous people. My last recommendation I would like to discuss with you is the necessity to ensure the effective participation of indigenous people, in particular in the EU decision-making process. 3 elements to reach this target. My first element is to reinforce and to strengthen the information, public participation procedures, and the respect of free, prior, and informed consent of indigenous people. Of course, the EU needs to be more respectful of the Paris Convention, and I give you another example of Escazú agreement could be which include the respect of expressively the respect of indigenous people. This aspect of reinforce the participative approach could be also, could be to reinforce the dialogue between the EU institution and the representative of indigenous people. I give you the example of the DOCIP office in Brussels. It just shows us that for indigenous people, the EU could be a very useful actor and to try to create a sort of stronger dialogue with the EU. Another element very useful, I think, is for the EU to help and to reinforce the support for indigenous people participation in international fora, for example, related to the Convention of Climate Change, the support of financial support from the EU, but also technical support for indigenous people and their representative. We could also imagine some member states include in their delegation at the international scale indigenous people. Why not the EU don't do such a thing? related always with imperative, I think it's very important to take into account the question of how to guarantee, how to ensure that the defense of their right and how to protect their defender could be more improved at the level of EU, of course, but not only on the level of EU. I give you some example of possibility to improve this question. For example, why not extend the scope of the protection under the new directive related to the protection of persons who report breach of union law? Why not? Why not included the human and indigenous right defender? I give you the example of Protect Defender EU program related the possibility for indigenous people to address complaints and claims if they consider they are affected by violation of their right. The last question, very important, is the question of the difficulty in accessing justice for indigenous people. If you are interested, the EU Agencies for Fundamental Rights, the last year adopted a report, very interesting report. In this report, the agency focus and put the accent of the difficulties for victims of corporate human rights violation and give example for indigenous people case. Of course, at the EU level, we are facing to the difficulty to access to the EU Court of Justice. Just before you gave the case of Cavallero, of course, in this case, we have an association of young Sami, and the Court of Justice declined that such association could have an individual concern. So how to go beyond such interpretation of the Court of Justice, it's very urgent question. And it's not only a question to access to the justice at the EU level, it's very important to reinforce, to strengthen the access to justice before the jurisdiction of member states in environmental and human rights issue, in particular related the indigenous people right. And I'll give you also another example. It's a case which are brought by association and NGO against a French company, EDF, for not respecting the principle of consentment of indigenous people concerning a white farm project in Mexico. It could be another way to push forward and to force the respect of indigenous people affected by climate change. So I think I need to finish and to conclude. So thank you very much for your attention. I give you an example of a recent book which I published with my colleague Sophie Thériault on indigenous people and regional integration. And the book was in the memory of an excellent colleague, Étienne Leroy, which left our planet last year, unfortunately. And I'll give you another example. We have a colloquium in the next month. I hope it could be possible to welcome different people, but I'm not sure. So thank you very much for your attention.
Thank you. Thank you for this clear presentation, Nathalie, which highlights the complexity and reality of the issue of indigenous people in the European Union, especially as this issue has always been dealt with from the perspective of inter-American states, and we have been used to listen to talks on the economic, political, and the human rights integration in the EU. So thank you for this innovative aspect of the relation between integration and indigenous people. Now I give the floor to Susana Borràs to talk about gender climate justice. Susana, hello, and you have 15 minutes for your presentation. Thank you.
Thank you so much. It's a great pleasure to share with all of you my presentation dealing with a gender perspective of the vulnerabilities regarding the climate change impacts. I will try to share my presentation. I don't know. Oh, let me. Give me a minute. No. Okay. So before to start, I would like to thank to Professor Campins and Professor Pentinat for giving me the opportunity to participate in this seminar. So as I said before, the topic of my presentation is focused on the position of women in the context of climate change, considering the concepts of intersectionality and climate justice, trying to answer the question why women are considered more vulnerable than men in the context of climate change impacts. This question was answered by the IPCC, the Intergovernmental Panel on Climate Change, in its fifth assessment report in 2014, when the IPCC recognized that women are not inherently vulnerable because they are biological sex. Women are not vulnerable as such, but the context makes vulnerable women facing climate change. Of course, there are several complex, dynamic, and intersecting power relations, another structural and place-based causes of inequality. Therefore, women vulnerability is clearly linked to a reality of inequalities which exceeds the reality of climate change. We can find a set of economic, social, and cultural factors behind this context of vulnerability. The existing gender inequalities caused by unequal power relations and a structure in the public and private sectors, discriminatory laws and customs, and unequal access and control of natural resources reduce the women's resilience to climate change impacts. In fact, 70% of 1.3 million people living in conditions of poverty are women. Women are highly dependent on local natural resources for their livelihood, particularly in rural areas in the global south. They shoulder the major responsibility for household water supply and energy for cooking and heating, as well as for food security. However, women have low participation in decision making, and they are not involved in the distribution of environment management benefits. This is particularly important in the case of women in many developing countries where gender inequalities with respect to human rights, political and economic status, land ownership, house conditions are more critical than in the global north. All these contexts of vulnerability based on poverty, social exclusion and marginalization, insecure land rights, heavy reliance on agriculture, less access to education and information, among other gender inequalities, are increasing with the climate change impacts, creating further vulnerabilities or exacerbating the existing ones. Women's capacity to cope with the effects of natural disasters is often impaired by prevailing inequalities in relation to discrimination, threats to health, loss of livelihood, displacement, migration, poverty, human trafficking, violence, sexual exploitation, food insecurity, and access to essential services. The reality is that women are less able to confront climate change because this context of vulnerabilities, and they also experience its effects disproportionately because their social roles, such as providing water, food, and combustible materials to family and caring for others. Women are responsible for more than 70% water source and management worldwide. In the regions most affected by climate change, 70% of all women work in the agricultural sector. And during extreme weather events, such as droughts or floods, women tend to work more to secure household livelihoods. And this leaves less time for women to have access to training and education, develop skills, or earn income. In many societies, sociocultural norms and childcare responsibilities prevent women from migrating or seeking refugee status in other places, or just working when a disaster hits. Such a situation is likely to put more burden on women, such as traveling longer to get drinking water or good for fuel. In sum, climate change will be another stressor that will aggravate women's situation of vulnerability. At this point, it's very important to consider the concept of intersectionality, since differences in vulnerability arise from non-climatic factors and from multidimensional inequalities. These differences shape differential risk from climate change. Of course, people who are socially, economically, culturally, politically, institutionally, or otherwise marginalized are especially vulnerable to climate change. This vulnerability is rarely due to a single cause. Rather, it is the product of intersecting social pressures that altogether result in inequalities in socioeconomic status and income, as well as in exposure. Therefore, and the different cumulative layers of discrimination determines being closer to the oppression area than the privilege zone, as you can see in this slide. So this approach of intersectionality has to apply in the gender context or in the gender analysis, allow us to refer to the concept of intersectional feminism. This concept was adopted by Kimberly Crenshaw in 1989, defining this concept as a principle, as a way to see how various forms of inequality can operate together and exacerbate each other. So it's very important to bear in mind that several factors interact and suppose an overlapping factors of discrimination, such as age, ethnicity, disability, poverty, socioeconomic status, as well, of course, gender, when considering the concept of vulnerability of individuals, groups of community to face climate change or to cope with climate change impacts. So it's quite relevant to consider that the concept of intersectionality is important, but also it's important to consider the concept of justice, the concept of climate justice. So the use of climate justice, including the gender perspective, is a way to highlight how climate change have different social, economic, and other adverse impacts on women, in particular women from the global south, where climate change is being felt disproportionately, comparing the low levels of their contribution to the global warming and considering the lack of participation in the decision-making processes. So it is important to highlight the inequality, but also the injustice. Therefore, it's quite relevant to use the concept of gender climate justice, just to recognize not only the disproportionate disproportionate effects of climate change on women, but also the relative role of women and their responsibility to cause the global problem, which is climate change, and also to highlight the low levels of participation that women had in the international negotiations. Considering the intersectionality and the gender climate justice, a process to deconstruct the gender vulnerabilities is needed. But it is important to start with the recognition of the important role that women play in preserving the environment. This was declared by the Principle 20 of the Rio Declaration in 1992, which recognizes the importance of women in the achievement of sustainable development. Therefore, it is important to include them in the participatory process of the adoption of decisions at international, national, and local level. Also, the Beijing Platform for Action in 1995 also recognized this important and strategic role of women to achieve sustainable development. Is it a question of justice to recognize the role far from the traditional role of victim, which is always recognized for women in relation to climate change or in the protection of the environment. Moreover, the Article 5 of the General Provisions of the UN Convention to Combat the Desertification recognizes the role of women in rural countries and in the regions most affected by desertification and droughts, encouraging the equal participation by both men and women, combating desertification and the effects of droughts. The CDGs, the Agenda 2030, acknowledge the link between achieving gender equality and the achievement of all CDGs, including the Goal 13 on climate change, providing the possibility to tackling the root causes of the weaker position of women and thus strengthening their resilience to climate change. So it's important to go deeper into the causes of vulnerabilities to recognize this role, this strategic role of women. For this reason, the starting point was to include women in the decision-making processes, and in the case of UN Framework Convention on Climate Change, decided at COP18 to adopt the goal of achieving gender balance in the bodies of climate change regime in order to improve women participation to ensure a more effective climate change policies that address the needs of women and progress towards the goal of gender balance in advancing gender-responsive climate change policy. With this goal in mind, at COP20, parties adopted the Lima Work Programme on Gender to advance in this goal, to guarantee the gender balance and to promote their representation in the developing and implementation of climate change policies. Indeed, in the adoption of Paris Agreement at COP21, the Paris Agreement itself establishes that the parties should consider their respective obligations with regard to human rights and gender balance when taking action to address climate change in their implementation of the Paris Agreement. So the most recent step further was adopted at the COP25 when parties agree to develop the Lima program. The Lima program was developed through a gender action plan. This gender action plan includes 5 priority areas with 20 activities in which this goal has to be achieved in order to guarantee the proper participation of women in the international talks. You can see in this slide the 5 priority areas of the Gender Action Plan. The first is to enhance the capacity building, knowledge sharing and communication. The second, gender balance, participation and women's leadership. Also coherence with the UNFCCC with other UN agencies. And the fourth is gender responsive implementation and means of implementation. And the last one, monitoring and reporting, just to encourage knowledge change activities among the different bodies of the climate change regime. It's not possible to go into detail in these priorities areas, but just I invite you to have a look at to this decision. Apart from the steps taken by the climate change regime, we have also the CEDAW, the committee, UN committee against the discrimination against women, in which have very important decisions. One of them is the general recommendation on gender-related dimensions of disaster risk reduction in the context of climate change, in which recalls to states to include women participation in order to reduce these vulnerabilities, this context of vulnerabilities increased by climate change or increased by fast onset disasters. But a part of this general recommendation, the CEDAW also adopted several observations addressed to Tuvalu and Kiribati, in which addressed to these states to actively adopt policies including women participation in the migration processes. So this is very, very interesting how to see this recognition of the specific impacts on women are focused on migration processes. The last observations that this committee adopted was last month. It was addressed to Denmark, and the committee recommend to the state to conduct a study on gender-specific impact of climate change on women in Greenland, in particular women depending on traditional Inuit livelihood, and report the results to the committee in the next periodic report. It is very interesting how to see, apart from the climate change regime, there are other UN bodies which are also dealing with this context of vulnerabilities from a gender perspective. And also it's interesting to see, we have been talking about climate litigation cases, so there is a case very interesting which is still pending, in which the plaintiffs were asking the responsibility to include the gender perspective into the elaboration of policies in the decision-making processes. It is the case of Maria Khan and others versus Federation of Pakistan. This case will be very interesting because it's the very first one to ask the state its responsibility to include gender perspective into the elaboration and the adoption of climate change policies. And last but not least, as always we said, at EU level, we have also several steps further in the recognition of the women and their context of vulnerabilities. In this case, it was the report taken by the or discussed in the European Parliament. Thanks to this report, the European Parliament adopted a resolution on women, gender equality and climate justice. This resolution is quite interesting to have a look at, because it's the very first time that the European Union is addressing the question of climate migration and how the climate migration is affecting the position of women vulnerabilities. So it is very interesting how the European Parliament is addressing this question and how is calling to the European Union to take an action. So this was a little bit what I wanted to present you today, just to highlight the most recent innovations in recognizing the gender climate justice, but considering also the intersectionality situation of the context of vulnerabilities that women face today, especially in the global South countries. Thank you so much, and I will be very happy if you make comments or questions about. Thank you.
Thank you very much, Professor Susana Borràs, for this very interesting presentation and for those beautiful pictures also, gender presentation, which deals in particular with an issue that is quite sensitive everywhere, which is the issue of gender, and which becomes much more sensitive when it is associated with the issue of climate change. So now I give the floor to Professor Rosa Fernández Egea, Climate Change Litigation and Human Rights, Addressing the Rights of Future Generations. Professor Rosa Fernández, you have 15 minutes for your presentation. Thank you.
Thank you very much. Can you listen to me well?
Yes.
Okay. I also would like to share a presentation. Let's see if I can manage. Okay. Can you see that?
Yes.
Okay. Great. So, good afternoon, everyone. And first of all, I would like to thank Mar and Ranma for inviting me to this seminar and to give me the opportunity to share with all of you my thoughts and concerns on a topic, climate litigation and human rights, that is of the highest interest and relevance nowadays. Indeed, there has been an incredible increase in climate litigation cases around the world before national and international courts. As you can see in the screen, there were almost 900 cases filed in 2017 in 24 countries, that almost doubled 3 years later with 1,550 cases in 38 countries plus the European Union. And many of them were dealing with human rights. In my presentation, I will focus on one specific case that is now pending before the European Court of Human Rights, which Professor Knox referred to, that will allow me to explore some of the existing concerns arising from the relationship between climate litigation and human rights, with a special focus on a very vulnerable part of the population, which is the children and future generations. I am talking about the case of the Portuguese kids, that is also the first climate case reaching the European Court of Human Rights. On the 3rd of September 2020, 6 Portuguese children and young people with ages between 8 and 21 filed a complaint before the European Court against 33 member states of the Council of Europe, all of the 27 European Union member states, plus the UK, Switzerland, Norway, Russia, Turkey, and the Ukraine. The applicants affirm that they are direct victims of the worrying impacts that climate change is having in their lives, and the respondent states are doing nothing, or at least not enough, to prevent those damages. In particular, they consider that the global warming affects the enjoyment of the right to life and the right to respect for private and family life protected by Articles 2 and 8 of the European Convention of Human Rights, respectively. In addition, they argue that there is also discrimination on grounds of age, and therefore an infringement of Article 14, which prohibits discrimination in the enjoyment of the other rights of the Convention. In October 2020, the European Court of Human Rights decided to fast-track the case based on the importance of and urgency of the issues raised, and governments will need to submit their defenses by the end of May. In my presentation, I will deal with two parts. The first one is where I will confirm an undeniable link between human rights and climate change by addressing all these 4 points. And in the second part, I will try to explore the obstacles and difficulties that applicants need to overcome in order to bring success to their claim. Since I will not have enough time to go all over the points, I just want to point out some of the most relevant ideas and will end my presentation with some preliminary conclusions. If we take a look at the general issues raised by the case, most of them are common to the many climate litigation cases. They address first the protection of the environment through the protection of human rights, what is known as the greening of human rights, that proves an undeniable link between a safe environment and the enjoyment of the fundamental rights. What also has been very well explained, among others, by the former UN Special Rapporteur John Knox, that we already had the opportunity to listen to, on in many of reports that you have linked to here, that you have the links available in this section. And the second point is also the undeniable link between climate change litigation and human rights, with an exponential rise of cases where the protection of human rights are the basis of a claim that has been called the human rights turn in climate litigation. The number 3, or the third subject, is the advantages of having an international human rights tribunal, such as the European Court, having to decide on a case like this. And you can find the advantages here. I don't have time to go over them, but you will have this presentation to take a closer look to it. And the fourth one is the necessity to consider the special situation of children and future generations when litigating about climate change on human rights grounds. I will just refer to this last point. Both the United Nations Children's Fund, UNICEF, and the Committee of the Right of the Child have declared that climate change is one of the biggest threats for children and future generations. Children are especially vulnerable dealing with climate change for many reasons. One, because of their age. They will live longer, so they will suffer longer the effects of climate change, and also taking into account that the magnitude and the severity of the harms will be greater as time goes on. Second, because the effects of climate change will hit them in a greater proportion if they are already in a vulnerable situation, such as poverty, special needs, or they're from indigenous populations, etc. And third, because they need to rely on others to carry on their causes. The extraordinary negative impacts of climate change on children justify the implementation of a child rights-based approach to climate change. That would mean that states need to take urgent action to protect them from foreseeable adverse effects and consider the best interest of the child when taking measures to fight climate change. But it is also necessary to take into consideration the principle of intergenerational equity in order to ensure the rights of future generations. In this sense, we can find references to future generation and children's rights in Article 3.1 of the UN Framework Convention on Climate Change and in the preamble of the Paris Agreement, in which states are called to respect, promote, and consider their respective obligations on, among other things, the rights of the child and intergenerational equity when taking action addressing climate change. The present case, as it has happened in many other climate change cases, poses serious constraints and challenges that I have divided in difficulties of a formal or procedural nature and a substantial or substantive nature. The formal requisites need to be met before the court can even decide on the merits. And regarding standing, although there may be many complications because of the diffuse nature of climate change in defining the effects on certain individuals, there should not be a problem in the present case to meet the conditions provided by the Articles 34 and 35 of the Convention. The real difficulty here is the second procedural requisite, namely the exhaustion of the national remedies. And that because the applicants have not used the judicial procedures available under the national law of any of the 33 respondent states before bringing this complaint to the international level, as is requested by Article 35.1 of the European Convention. In that regard, the applicants have asked the court for an exception to that condition with some interesting arguments. First, it is virtually impossible to litigate in parallel in each and every judicial system of the 33 states parties. Second, even exhausting the national remedies of only one or two countries, it would be not enough since all the emissions of all respondent states contribute to the climate change effects that are felt in Portugal, where the applicants live. Third, because of the status of the applicants, being children and young adults, they lack financial means and resources to claim before the courts of all responding states. But in my opinion, the strongest argument is the last one, the fourth. To comply with the exhaustion of national remedies would involve too much time, delaying a state action that is already too late. Time is here a value and time is running out. In the case that applicants succeed meeting the formal requirements, the court will have to judge on other interesting issues in order to assess the impact of climate change on the right to life, the right to private and family life, as well as the right not to suffer discrimination in the enjoyment of these other rights. The Convention of Rome does not provide a fundamental right to a healthy environment, but that has not prevented the European Court to decide on a case where states had to fulfill environmental obligations when needed to protect the fundamental rights enclosed in the Convention. In order to confirm a violation of the Convention, the applicants have to prove, first, a serious interference of which are directly affected. Second, that this situation is due to a direct action of the respondent state or a failure to sufficiently protect the individual against such interference. And third, all that taking into consideration that the states enjoys a wide margin of appreciation to determine if the interference of the fundamental right can be justified with a general interest. The first 2 points refer to the problem of proving a causation link that works in two ways. On the one hand, the direct relationship between the effects of global warming with the particular tangible harm or interference to the enjoyment of a certain fundamental right for the applicant, what has been called the impact attribution. And on the other hand, the direct nexus between the action or inaction of the respondent state and the production of climate change, what has been called as source attribution or just attribution. These causal links are hard to draw, considering the diffuse nature of climate change, but they are not impossible. I don't have here the time to go all over these points, but I just want to mention that in my opinion, they can be met by using arguments of scientific evidence and due diligence obligation of states in preventing foreseeable serious harm for current and future generations. Even though one can affirm that there has been a serious interference directly affecting the applicants that is attributable to a responding state, we still need to take into account that contracting states have a wide margin of appreciation in choosing their policies to protect the environment or to fight climate change. But it doesn't mean that the court cannot supervise or control if there has been a reasonable balance between the right of the applicants and the general interest that justifies the interference of the given fundamental right. In this regard, the margin of appreciation or the margin of discretion in choosing their environmental and climate policy should not be that broad, because there's already scientific evidence that shows that exceeding 2 degrees global temperature will most probably cause serious and irreversible harms. Therefore, for this matter, the court should take into account that states have an obligation to prevent foreseeable and serious harm that, according to the Paris Agreement, would mean to do all what it takes to comply with the goal of not exceeding 1.5 degrees. Not to do so proves, in my opinion, that the states have acted with negligence and consequently have overstepped the wide margin of discretion. And finally, coming to the preliminary conclusions of my presentation, I have to say that this is not a clear case. It's not an easy one, but none of the climate cases were easy so far. Certainly, I cannot venture what's going to happen. I could just speculate. But one thing is for sure, if the court decides in favor of the applicants, it would imply somehow that the European Convention encloses a positive obligation of states to protect human rights for current and future generations through fighting climate change. It might be not an obligation that includes a specific quantitative emission reduction, but emitting above a certain benchmark, certain level, would come to a violation of the fundamental rights to life, to respect a private and family life, and to the right not to suffer discrimination in the enjoyment of these other two. I'm not sure if the European Court, let's say, it's brave enough to take such a decision, but in any case, one thing is for sure, a correct decision in terms of climate justice requires, in my opinion, taking into consideration the principles of intergenerational equity, best interest of the child, as well as interpreting the convention in the light of some rules and principles of international environmental law, such as the harm prevention rule and the precautionary approach. I would like to end my presentation with some words of Greta Thunberg. The eyes of all future generations are upon you, and if you choose to fail us, I say, we will never forgive. Let's hope we don't come to this situation, because that would mean very bad news for all of us. Thank you very much for your attention.
Thank you, Professor Rosa. Thank you for this stimulating presentation, which seems to me to be very challenging, as it puts the rights of future generations at the heart of the debate on climate disputes, climate litigation, a rather sensitive issue before courts around the world, given to this close relation between the rights of these future generations and the evidence to be provided on several levels. Now it is Delphine Ducasse's turn to talk about the inclusion or lack of environmental provisions in free trade agreements between countries vulnerable to climate change. And I would just like to mention that this presentation was conceived in collaboration with Mrs. Michelle Herder, who is also a PhD candidate at the University of Sherbrooke, but given to the limited time to intervene, it is Delphine Ducasse who will present on behalf of both. Well, thank you.
Okay, just Delphine, do you need me to share your presentation?
Well, I'm trying to import it. I just tried to import a new document, which saying that it's coming, but...
So,
okay, you have it. Great, thanks.
You only need to move on the bottom of your screen. You can move there, okay?
Wow, this application is really amazing. By the way, first time that I'm using it, it's going really well. So thank you very much, and I would like to thank, of course, Dr. Capent and Dr. Pentinat for the invitation to participate in this extremely interesting seminar. I'm kind of disappointed of doing it from rainy Montreal here instead of being in sunny Barcelona, I'm sure. And I would also like to thank Michelle Herder, as Dr. Pentinat said, for her contributions to the preparation of today's presentation on the inclusion or lack of environmental norms in free trade agreements between countries vulnerable to climate change. So this map here is very similar to the map that was showed by Professor John Knox a bit earlier, and it shows the countries that are most at risk from climate change, and especially extreme natural events. So the World Risk Index, it's a statistical model for assessing the global risk of disasters that arise directly from extreme natural events. It is based on the notion that disaster risk is particularly high where extreme natural events hit vulnerable societies. So we have two variables here. The first one being the occasion of extreme natural events, and the second one, the vulnerability of the societies that are being hit. So it assumes that social factors such as political conditions and economic structures are also responsible for whether or not a disaster occurs in the wake of extreme natural events. And as we know, extreme natural events such as floods, the rising of the sea level, wildfires, storms, typhoons, droughts, and others are exacerbated by climate change and global warming and are happening more and more often. So looking at the map here, we can see that the countries that are most at risk are mostly in the global south, even if we have some countries that are in the north, but the vast majority of them are considered to be in the global south. So from this table here, we can see that Africa is the continent that is most vulnerable continent, particularly in Western Africa, where countries like Cape Verde, Niger, and Guinea-Bissau have a high risk index, which is the first column here, which you can see also the exposure to natural events and the vulnerability of the society. In Oceania, we have also a lot of vulnerable countries or countries at risk, especially with the smaller islands like Vanuatu, Tonga, and the Solomon Islands, which are particularly exposed to the level of the sea that is rising. We also have extremely vulnerable countries in Asia, such as Brunei Darussalam, the Philippines, and Bangladesh, with typhoons and also the level of the sea. And we also have countries at risk in the Americas, especially in the Central American countries like Dominica, Guyana, Costa Rica, Haiti, and Nicaragua. So with this table, you can see that in these countries or in this continent, the risk is seldom higher than the worldwide risk. So for example, especially if you look at Oceania here, which is calculated risk at 15 compared to global being the worldwide risk being 6.42. So it's extremely higher. And we can see that, for example, I'm not really talking about Europe because the risk is at 3, so which is lower than the worldwide risk. So what about the other part of my presentations, which is the environment and trade, which is a new trend that has been happening since the 1990s, especially since NAFTA has been concluded in 1994, which was the first regional trade agreement to include comprehensive environmental provisions in a free trade agreement. This was pursuant to the tuna-dolphin dispute between Mexico and the United States, where at the GATT level, the United States lost their case to protect the dolphins from the tuna fisheries that was happening. And so there was a lot of pressure in the United States to renegotiate the free trade agreement with Mexico and, incidentally, Canada. So following the election of Bill Clinton, there was a renegotiation, but instead of including the environmental norms in the core of the free trade agreement, it was decided to add a parallel agreement, which is the North American Agreement on Environmental Cooperation, which is then with the new NAFTA, which is the Canada, United States, Mexico Agreement, or the United States, Canada, Mexico Agreement, so depending which country the name changes, which is very confusing. But now there is a chapter on the environment in the core of the agreement. So from 1990s onward, there's a sharp increase in the number of free trade agreements that include environmental norms, accumulating to approximately 20 new trade deals concluded now each year, which includes at least one environmental norm. Also, from the trade database, with the Trade and Environmental Database, which was created at the Université Laval here in Quebec, Canada, and they recensed 308 different environmental norms in all of the free trade agreements that have been concluded since 1947. So we can see there's a lot of variety in the type of environmental norms that are included in free trade agreements, but the most popular ones are the exceptions that are found in GATT Article 20 on the protection of the health of the environment and also the natural resources. So which states tend to include environmental norms? So we can see from this graph here that the regional trade agreements that typically contain the most environmental norms are North-South regional trade agreements. So trade agreements between countries in the North and in the global South. So it's the graph in the middle here. So we can also notice that there are majority of trade agreements between North and South countries, but they're the ones that tend to include the most environmental norms. There's also the most recent North-North regional trade agreements that also contain comprehensive environmental chapters. So we can think about, for example, the Canada-EU trade agreement, so CETA, that was concluded in 2016, that include a high number of environmental agreements. So on average, North-South agreements would typically contain around 32 norms. Keep in mind that this average include all of the free trade agreements concluded since 1947. So as we can see in the graph here, also there's a sharp increase, as I said, from 1990s onwards. So these averages are a bit lower because they include agreements from, for example, the 1960s. But on average, so the North-South agreements contain 32 norms, as opposed to 12 for trade agreements between northern countries and 8 for trade agreements between southern countries alone. So there are also some South-South free trade agreements that contain many environmental norms, such as the free trade agreements between Nicaragua and Taiwan, for example, in 2006, or the one between Colombia and Korea in 2013. Keep in mind, though, that Korea now has stated that it is does not consider itself a developing country anymore. So can it be considered a southern country is up for debate. But the most interesting one is probably the Argentina-Chile Free Trade Agreement that was concluded in 2017 that contained an entire chapter on trade in the environment. And in their context and objectives, they state that the parties recognize that the environment is one of the 3 dimensions of sustainable development and that it should be addressed in a balanced manner with the social and economic dimensions. In this regard, the parties recognize the contribution that trade could make to sustainable development. So this chapter is extremely interesting because they also contain many norms regarding the right to regulate in environmental manners, some environmental commitments such as access to justice, information, and participation. There's also a provision on corporate social responsibility, another one on fisheries matters and forestry matters and sustainable agriculture. So it is a first South-South agreement that contained that many environmental norms and comprehensive one as well. The 10 regional trade agreements that contain the highest number of environmental norms will typically always include either the United States, Canada, or the European communities. So for example, the regional trade agreement that contained the highest number of environmental norms so far is the Canada-United States-Mexico agreement, so NAFTA 2.0, which contained 145 norms. Following that, we have the European communities with Central America, the Trans-Pacific Partnership, also a number of free trade agreements with the European communities, with Vietnam, with Armenia, Moldova. We have CETA that I've talked about as well. So the 10 regional agreements that contain the highest number of environmental norms always have at least either the United States, Canada, or the European communities. So combining now the vulnerable countries to climate change and to extreme natural events that we saw at the beginning of the presentation and the trend of including environmental norms in free trade agreements. So if we combine these 2 variables, we can see that typically vulnerable countries will not systematically include environmental norms that would protect them from and mitigate the effects of climate change. So for example, if we look first at the Pacific Islands, so it's important to note as well that a lot of these countries also do not have many trade agreements because they are typically smaller countries that have smaller economic activities as well. So for example, the Pacific Island countries trade agreement that was concluded in 2001, which the Cook Islands, the Federated States of Micronesia, Kiribati, Marshall Islands, Samoa Islands, Tonga, Tuvalu, and Vanuatu are parties to, only have 4 environmental norms in this trade agreement. And 2 of them are the general exemptions of Article 20 of the GATT. So we can see that this particular norms or have it at the core of the trade agreement. If we look after that at Africa, the most interesting one being the African Continental Free Trade Agreement that was concluded recently in 2018 that only has 9 environmental norms included in the free trade agreement. And that is especially disappointing since the African Charter of Human Rights do have the right to a healthy environment included in the charter. But we can see that when you have African countries, here the West African states, conclude a trade agreement with the European communities, the number is much higher with 36 norms. We have a similar trend in Asia where when the vulnerable countries are doing trade agreements between themselves, such as ASEAN, for example, which include Brunei Darussalam, Cambodia, Indonesia, Malaysia, Myanmar, Philippines, which are, if we go back to the map at the beginning of the presentation, are all considered on the vulnerability part to climate change that have a very high risk. The ASEAN agreement only has 4 environmental norms. But if you have, for example, the ASEAN with the New Zealand or Australia, go to 45 norms. And in the Trans-Pacific Strategic Economic Partnership, which has Brunei Darussalam, you have 55 norms. And the same thing goes with the CPTPP, for example, which has Brunei as well in it, which has more than 100 environmental norms. So we can see that between themselves, it's not necessarily, but when you have a northern country in agreement, the number of environmental norms will typically be higher. Same thing in the Americas, with the exception of Argentina, Chile, that I've already talked about. And when you have, for example, Central America with Panama, you have 28 norms, which is not too bad. But when you have the East Central America with the European communities, you go up to 34 environmental norms. So to conclude, what are the trends? What can we see with these vulnerable countries to climate change, and whether or not they include environmental norms in free trade agreement? So there is a trend for sure to include environmental norms in regional trade agreements, especially between northern and southern countries. So the vulnerable countries, when they do have a trade agreement with a northern country, they will typically have higher environmental norms included in a free trade agreement. And there's also an inclination to reproduce environmental norms that have already been included in one regional trade agreement. So the most interesting one being with Argentina-Chile agreement. Chile is a party to the Trans-Pacific Partnership and now the Comprehensive and Progressive Trans-Pacific Partnership Agreement. So we can see in the Argentina-Chile Free Trade Agreement that are some norms that are reproduced that are almost exactly the same as an environmental norm that was included in the TPP. So we can see that once a country or developing countries or vulnerable country has included environmental norms in a previous regional trade agreement, it may be more likely to include some in the future trade agreements. What we can also see is that the vulnerable countries not yet systematically include environmental norms as, for example, the United States, Canada, or the European communities would do. So especially in South-South regional trade agreements, we cannot see a lot of environmental norms that are included. It tends to change, but it's still very much in the lower range of environmental norms. But one reason for that may be that a lot of the developing countries at the WTO, for example, have advocated for differentiated responsibilities with respect to the protection of the environment to be able to benefit from the economic growth of trade. So if we take that position and took it to the vulnerable aspect or the at-risk aspect of countries to extreme natural events, the economic growth from free trade agreements will necessarily impact the vulnerability aspect. So by having a more resilient society and having the economic means to mitigate the impact of climate change and also reduce the impact on the population, we can still improve the risk of vulnerable countries even if they don't include environmental norms in free trade agreements. So by not having environmental norms and reducing the possibility of trade, they are still impacting on their vulnerability to climate change, so they can still have a positive impact even if they do not yet include environmental norms in free trade agreements. So to that, I thank you all for listening and open to questions, obviously. And if you ever have any question, can contact me on my email address. Thank you very much.
Thank you, Delphine. And through you, thank you also to Michelle Herder for this interesting presentation, which highlights the complexity always of balancing the interests of climate change and international trade, a balance always difficult to achieve in all regional organizations, including the EU. So now we can start the debates, and you can ask your question to the different panelists. Do you have some questions, please? If you agree, I can begin with two questions, if you are okay to let more time for the audience to prepare other questions. So I have one question to Nathalie and another question to Professor Rosa. My question to Nathalie, you mentioned it in the title of your presentation, which I find really very stimulating, taking seriously the rights of indigenous peoples in the EU framework. And I had this impression during your presentation, Nathalie, that in the EU framework, it is really this concern for economic integration that is blocking almost of many things, including the balancing of economic and environmental interests, for example. So do you think, as I did, that this economic integration is really blocking the recognition of the rights of indigenous people, or is it really political concerns that come into play? And I have a question to Dr. Rosa Fernández. I found your words really very courageous in talking about the rights of future generation in the context of climate disputes, climate litigations. And I find this courageous because we already have a problem with the rights of current or even past generations in current and future environmental disputes. So what can we say about the other subject of rights that do not yet exist? And I know that before the European Court of Human Rights, the issue is quite complicated for these future generations because there is a complicated system of proof, etc. So I don't know if you can give us some indications on some successful cases before the Inter-American courts to defend the right of a future generation. Yes, I don't know, Nathalie or Professor Fernandez want to begin.
Thank you, Rama, for your question. It's a very interesting question because at two levels, at the level of the European policy and at the level of the Court of Justice of the EU. Very interesting. At the EU policy level, I think the EU is not so comfortable in the field of human rights. I think it's easier for the EU as an economic actor to play at the international level and to push the different type of policies such as agreement, trade and investment agreement, and to try to include the human right and to try to put the linkage between human right and indigenous people, and etc., etc. So, and I think it's not so bad solution because, as I said, the European Union is an economic player, very important economic player. And I think the measure of its responsibility is in this field. Related to the question of the position of the Court of Justice, very interesting too, because if we take the example of the people climate case, when you read the decisions of the court the last month, the court always say, okay, it's not possible for me to go forward the interpretation of the jurisprudence of Plowman related to the individual concern. And it's not possible for me to go forward despite the recognition of the right to have an access to justice according to the Charter of Fundamental Rights. And when you read over decision of the court, she accepts some derogation, she accepts some exception to go forward the interpretation of Plowman jurisprudence in the light of economic issue, which she decided to take into account. So I think the EU, according is important economic dimensions, she's not so comfortable. So I will think again about your question, but I think you're right. It's always, how to balance the question of economic dimension and human right. Of course, human right is linked into the rule of law, and the Court of Justice focused this aspect to say, okay, the EU is based on a rule of law, need to respect human rights, so it's very fundamental aspect, the rules of the EU, but yes, yeah. I think it's a difficult aspect, you're right.
Yeah, thank you very much for your response. And I think also that, yeah, the application of the principle of proportionality also can play an interesting role in this play of balancing between environmental interests and economic interests. Yeah.
Yeah, but I think unfortunately, the court decided not to accept the request of the plaintiff, but I think it would be very interesting if one day the court accepts to evaluate, to assess the different arguments, in particular in the light of proportionality principle. But we don't have enough, no case.
Yeah. Thank you, Nathalie.
Well, to try to answer to your question, Dr. Pentinat, that I really appreciate. I'm not sure I have any ideas or encouraging cases that will bring some light or hope regarding future generations. I think it's also a matter of what do you consider as future generations. If you consider the people that are not already born, then it's really difficult, because human rights are usually claimed only by people that are already here, current generations. So there is, so as far as I'm concerned, as far as I know, there are no catalog of human rights that can address a right for people that are not already in this world, and or many, or very, very few exceptions. That doesn't mean that in the future we can have a right of a healthy environment also on behalf of future generations. But first we have to have a right of a healthy environment. That's still something in developing, right now. So if we consider future generations as children, for example, because we always say children are our future, they're also future generation in a way, then we have more chances to have some success before tribunals and courts, because there are increasing cases where children and youth are being plaintiffs, are claiming before the tribunals, before national and international tribunals. And usually in the cases where children were the plaintiffs, as long as they can prove that there were some harms and they were directly affected by those harms, then even though they can act also on behalf of future generations, courts tend to overlook these future generations' complexity and accept the extending of these children in order to proceed with the case. but there aren't that many cases where really successful judgment. And I don't think before the Inter-American, that was your question, I think, before the Inter-American Court. I'm not sure there is any case if you're not linking it with the indigenous rights, because of this not well-defined time framework of indigenous rights, because they deal with past and future generations, like the right to have the right of property of the land. It's not just of particular individuals, but of all population, and they enclose past and future generations. But apart from that, I'm not sure, and at least I don't know of any cases that really deal with future generations. Maybe someone in the here in the of the people listening to us, maybe they know, but I don't.
Yeah, okay. I'm not sure, but you can correct me. I think that in front of the Supreme Court of Philippines, there was a process concerning the right of future generation. I think it is not really related to indigenous people. It is related to the right of children. And I don't know if it is that or no.
I was talking about the Inter-American.
Yeah, but out of the Inter-American, there are,
Well, but they were always children together with the future generations right holders.
Yeah.
I'm not sure there is one case where only people were acting on behalf of future generations and not of themselves also.
Mm-hmm. Yeah. Thank you very much for your answer. Thank you. I see here in the chat that there is a question for Delphine Ducasse from Professor Xavier Fernández Pons, University de Barcelona. What about free trade agreements led by China?
Yes. What about China? Well, extremely interesting and very disappointing was the recent RCEP agreement that was led by China, and it contains absolutely no environmental norms or no environmental chapter. So yes, China is very not a proponent of environmental norms. And which was very interesting was that at the start of the TPP negotiations, the goal of the United States was to try and bring as many Asian countries in the agreement to be a counterbalance to China in the region, and especially and to have chapters such as environmental chapter, but also a labor chapter, and some democratic norms also included in it. And so unfortunately, as you probably all remember with Trump when he was elected, withdraw from the Trans-Pacific Partnership. And so it led the way for China in the RCEP, which contains absolutely no environmental norms. So yes, extremely disappointing, but very understandable when we know a little bit about China, which is, as Professor John Knox showed, that it's a large portion of the carbon dioxide emissions from China. So I don't think it would ever be a proponent of environmental norms in free trade agreements, and to limit themselves from their economic growth, especially since they also always consider themselves a developing country, which has, various arguments on both sides as to know if China is a developing country or not. But yeah, so China is not does not really include environmental norms in their free trade agreements.
Thank you. Are there other questions? Yes, Mark Campins.
Yes. Well, it's more than a question. I think it's a clarification. Actually, it's addressed to Susana Borràs. You mentioned that, of course, the concept of climate justice should include the gender's perspective, and that the gender perspective should at the same time be analyzed through this concept of intersectionality. So my question is about that. I understand that this is an approach that has to apply to gender issues, but I cannot really see in practical terms what is the added value of the intersectionality idea. I mean, what is just adding to the analysis of climate justice issues? So maybe it's that I don't understood the concept. I think it's a methodological tool. I understand.
Yes, it's a way to highlight the discrimination, the rate of discrimination against women, in the sense that women comparing men in a context of intersectionality have a bigger burden facing climate change, especially because women has been traditionally excluded from the decision-making processes, in particular at international level. So the climate change secretariat in Bonn has recognized several times that there was a lack of participation in women. For women in the international talks. So there is a call from the climate change secretariat to involve the role of women in taking the decisions. Is why the climate justice movement is calling the gender climate justice as a part of climate justice, because women has been non-responsible, but are being affected, highly affected by climate change impacts in several parts of the world. In intersectionality is important because women, in particular women from the southern countries, from the global south countries, are being exposed but also excluded from the political decisions. Political decisions sometimes taking decisions on mitigation or adaptation policies. So it's quite complex to combine, but it's very necessary to consider the climate justice together with this intersectionality, because the intersectionality for men is not working at the same level for women. So is why I try to make this mixture between the theory of Kimberly Crenshaw with the climate justice movement. And the climate justice movement includes itself the question of gender justice, because yeah, it's a way to claim for the androgenic responsibility for the climate emergency. So it's difficult to see, but I think it's necessary to better understand the context of vulnerabilities that women face. I don't know if I answer your question. It's quite complex, but I'm still working on this topic.
Thank you, Susana. I'm looking here in the chat. So for a question for Dr. Rosa Fernández from Paul Palas, there is this definition of sustainable development as the balance of intergenerational equity with the intragenerational equity, identifying the first with environmental and climate protection and the second with economical development. Do you think that this is a fair definition, taken in account that present generations are already at this very moment affected by environmental risks?
Sorry, I had my microphone turned off. It's a very good question, because, yeah, it's not climate change. It's not a problem for the future. It's already a problem nowadays. I think that's what Paul was trying to say here. And But one thing is also for sure that as time goes on, the problem is going to be greater. So I think that makes a differentiation between what effects we're going to currently suffer and what effects are going to be suffered by the future generations. And not only that, but also because the problem of climate change is going to be more difficult to deal with also as time goes on. And it's also a problem of justice and equity, because as John Knox said already, the people that are not creating this problem are going to be the people that are most suffering from it. Not only current vulnerable people in the global south nowadays, but also in the future. So I think that this definition is still correct and has a good point. So I think it's valid from a human rights perspective. I don't know if I answered the question. If not, Paul, then you can always ask again.
Thank you, Professor Rosa Fernández. There is another question from Professor Alex Peñalbes de Cabré. Does climate change vulnerability force to recognize environmental crimes against humanity?
Well, I don't know if it's addressed to me, but I can say something.
He didn't mention in reality.
Well, I think I think
it is addressed to all panelists, yeah.
Okay, then I'll give my opinion, and all the other panelists can also give their opinions. I think if we continue with business as usual, then it's really a risk that we come to this. Well, a risk. It's going to be a necessity that we consider that states, but also private persons like corporations could be responsible for an environmental crime. And in this sense, there are some initiatives to consider a new delict, I think is the name, that deals with ecological disasters that could also be dealt with before the Criminal Court of Justice. The International Criminal Court of Justice is something that some people are working on, and I think we're gonna see it with our own eyes. An international level, because at the national level there are already many states that are considering environmental crimes already.
Okay, thank you very much for your answer. I think that there are no more questions in the end of this debate, so I think that I can conclude this session. I want again to thank all the panelists here today for your disponibility, for your time, for your interesting presentation. It was really so interesting and so rich debate with you about vulnerability in many approach, gender, future generations, and thanks again also for Professor John Knox, especially for his interesting approach concerning the human rights crisis in relationship with climate changes. Mar?
Sorry. Yes, so thank you very much. So I would like, just as a holder of the Jean Monnet Chair and co-organizer of that seminar, I would like first to thank Professor Rama Bentirou, yes, for her initiative, and well, for her support in the organization of that seminar. And I also would like to thank all of the speakers, all of the panelists for your interesting presentations. And of course, I want also to share our audience, especially those who have been here for the whole day. It's Friday. It's now Friday afternoon, spring, and 6 in the afternoon. So it's really well, a nice support for the activities of our chair to count on all of you. I hope that with that session we were able somehow to make it a little bit clear, or even to provoke new, or to suggest new ideas about that concept of vulnerability, which is here to stay probably, and we will still hear for years and years about that concept. And we will we had seen today how it can be approached for so many different perspectives and so many different approaches, and from the legal, and from, let's say, more political, or from more sociological, or from some, but anyway, it can, I mean, it's probably this kind of concepts that, as Rama has mentioned before, may be a little bit used as a kind of toolbox, but it may be used for almost anything. So I think it still needs work to analysis to go on the core of that concept, and we hope that we'll be able to continue this line of work. So nothing more to say. Thank you very much to all of you. As I said, thank you to our speakers, our audience, our presenters, and that's all. Thank you very much. Okay.
Thank you, Mar.
Thank you, Mama and Mar.
Bye.
Thank you.
Bye-bye.
Goodbye. Have a nice evening.
Thank you.
Thank
you.
you very much.